April 1973, Delhi. 13 judges sat on biggest case in India's history. 6 said yes, 6 said no, split in the middle, and then one vote that changed it all. In the early 1970s, this was just a few years before emergency, Indira Gandhi believed that parliament should have absolute powers. The government has already started taking away private land and property in the name of land reforms and social justice, which by the way was a fundamental right back then, Article 31 right to property. Now imagine this bigger. कल को government decide कर सकती है कि elections नहीं होंगे, लोग कोर्ट नहीं जा सकते और किसी भी तरीके की freedom नहीं रहेगी. And back then it wasn't some crazy fear, because legally it wasn't impossible. So what changed? This is where it gets interesting and something that you would want to remember by. This was challenged in the Supreme Court by a priest from Kerala, Keshwananda Bharti. His primary concern was losing his temple land to the government reforms. But once his petition reached the Supreme Court, the question turned into something way bigger. Does Parliament's power have any limit at all? A historic 13-judge bench, biggest in the Indian history, heard the case. After 68 days of argument, the judges were split. And finally, by one vote, 7 against 6, the basic structure doctrine was introduced. So yes, the parliament would be able to amend the constitution, but it cannot touch its essential core. Election, separation of power, freedom of speech, rule of law, election and justice. And what we just discussed was the good old Keshwananda Bharti case versus the state of Kerala.